My name is Jeremy Shaw. I am a member of the office's CLE committee, and it's my pleasure to introduce our next plenary presentation and speaker. Up next is a presentation on ethics given by our own Chris Lacombe. I don't know if he has a Facebook page or a Temple Recommend, but I have been informed that Mr. Lacombe is a graduate of Western New England College of Law. After graduation, Chris worked as a JAG for the U.S. Navy, where he practiced both court-martial prosecution and defense. Following the Navy, he worked in private practice as a litigator, where in a murder case he was able to use the sleepwalking defense. Following private practice, he returned to public service as a regional attorney for New York State's Department of Environmental Conservation, where he spent significant amounts of time bringing municipal and industrial wastewater sewage facilities into compliance with their permits. Chris joined the AG's office here in 2011 and worked for 3 years in the National Resources Division as an attorney in the public lands section in the state's effort to quiet title to over 12,000 roads. His exemplary service there is highlighted by his friendly salutation to skeptical rural landowners, which was, "I am from the government and I'm here to help." Chris has since joined the True Education Division and has represented the State Board of Education and Salt Lake Community College. In the past, Mr. Lacombe was also an elected member of a public school board and an instructor at the college level for about 20 years. He is a true officer and a gentleman. Let's all welcome him.
Yeah, thanks. And see how this... How do we get this working? Oops. Okay.
Now do you have it on members? You got this right there.
Stand that baby right there. Right, yeah. And I hit this to move along, or
Yeah.
if I hit down, or?
Oh, no, you hit over.
Okay. Okay. All right. I need this. Bottom. This presentation is on ethics, and it has a slant on technology. And as you can see from my ability to work this laptop and my ability to work this microphone, I don't have a real strong competency as those who have worked with me on technology. Furthermore, in the 20 or so years that I've worked, 32 years that I've worked as an attorney, I've actually been before the bar on 3 occasions, albeit in New York State, which is where I'm from, and with respect to complaints. So there's maybe some questions as to how ethical. Fortunately, every one of the complaints against me, which were sort of crazy, one was a parole appeal, one was a defense counsel taking a scorched earth policy in a hunting over a bait trial that I did as an environmental lawyer, complaining, and I was cleared. But I'm taking the process or the approach in this that most of us here are trying to do the right thing. We're trying to do the right thing, and so I'm going to focus not on reported case law, but more on advisory opinions, which are more proactive in the sense that people are trying to figure out what the right answer is to the dilemma they are in. In this presentation, I'm going to deal with essentially 3 things. First, I'm going to deal with an antitrust case that came from the Supreme Court that may have some relevance in the bar's regulation of our profession. 2, what are the disciplinary violations that are being committed by Utah's bar members. Then I'm going to get into the guts of the presentation, which are the ethical issues, again with an emphasis on technology, regarding 1, diligence, 2, confidentiality, and 3, communication, and as they all lead into competence. All right. About a year ago, we had a case for the Supreme Court. I suspect the people in our antitrust unit are familiar with it. But what it dealt with was an assault by the dental profession on non-licensed dentists providing teeth whitening services. And the North Carolina Board of Dental Examiners, which was a group comprised almost entirely of dentists, sent out about 50 cease and desist letters to people who were doing dental whitening that weren't dentists. The FTC, or the Federal Trade Commission, brought a complaint, administrative complaint, and the issue was the Board of Dental Examiners protected as a state entity and exempt from the requirements of the Sherman Antitrust Act. And what the Supreme Court made a determination on it was, no, they are not. And what the basis of their decision was, you've got the issue of a state can relax antitrust concerns and deal with if it's regulating an industry. But it can't really, we don't really want it to be non-competitive. And the court said, in doing its analysis, that while there's an interest in regulating the dental industry, there was no specific statutory requirement that the dental board had the authority to deal with teeth whitening issues. Secondly, the court looked also at, this is a state entity, but it's a board comprised of dentists who have somewhat of a selfish motive here in preventing other people from non-dentists from doing teeth whitening, which they were doing. And what the court said with respect to that is there needs to be active state supervision, okay, of these boards. It just can't be the dental profession regulating itself. The result of this was that the Washington State Bar actually suspended some of its ethics opinions because of antitrust concerns in the cases where they could be defined or conceived as anti-competitive. If you look at Utah law, okay, the power of the bar ultimately comes from the Supreme Court. But the composition of the committee that does the lion's share of the work is comprised of lawyers. And that committee is supposed to be the profession is supposed to be sort of self-governing. We're gonna do it ourselves. Is there a problem with this Utah State Bar has with antitrust? Probably not. And I say that in light of this decision. If their actions of disciplining attorneys, admitting attorneys, of that nature, if their actions, one, are supervised by the Supreme Court, actively supervised by the Supreme Court, and 2, tend not to be anti-competitive, then we're probably okay. Okay, the second area that I want to deal with is just looking overall at what the violations being committed by the Utah State Bar are. This comes from their annual report from 2015. And the bottom line to all of these numbers is about 3 to 5% of the cases that are opened end up with an order of discipline entered. So, in other words, it's a very small number. Those complaints, about half of the complaints that come from the clients, about 15 to 20% come from the opposing party, and the other third come from the other sources that are on here. In those orders of discipline that are issued by the court, essentially the first 2, diligence and communication, they're the biggest number. And and because of that, we are going to focus on some of those issues today. We are also, in the middle of this bar chart, we're also going to focus on a smaller thing, but what I think is important, confidentiality and competence, which are a much smaller number. But certainly that competence issue in all of these decisions permeates the decision. I put this up there because us lawyers, at least this lawyer, and a fair number of lawyers that I've dealt with, we're not always the most organized people. And we may have email accounts that are a mess. Our Word documents are not organized. And it may not be in the sense of Einstein here, that we have a cluttered desk, although many do. But our desk now, or our paper repository or information repository now, is our computer. The second thing I put this up here for is I know my wife tells me, and I suspect most of our administrative assistants will tell you, those lawyers, they are really smart people, and they are idea people, and they have all kinds of, real good ideas. But you know what? Sometimes they lack common sense. They're not real organized. And so I put these things up here, because our propensity for ideas and going like this, sometimes maybe it's woven into some of our DNA, our lack of organization can create problems with our diligence, whether it be in the context of procrastination, or let me think about it a little bit more, or communications, let me research it, or in the sense of confidentiality. Diligence. Let me make sure I got okay. Diligence. I think we've all heard or seen this rule. We should act with reasonable diligence and promptness in representing a client. And I certainly remember in my second year of law school learning about the importance of zealous advocacy. Diligence is zealous advocacy. And I hope that in the process of my practicing law, I generally have had that. But when I was 25 in taking my ethics course in law school, I maybe didn't have an appreciation of comment number 2 on here, which is our workload must be controlled. And then I learned as decisions got tougher and tougher, and I wasn't always certain as to what the answer to a problem was. Comment 3, the importance and sometimes the problems of procrastination. So I put up a half a dozen, or excuse me, 4, I think, cases up here. And near the end of the Utah Bar Journal every month, there's an ethics corner which they talk about the disciplinary problems of that lawyers are going and what they're getting. But I put the image of a train wreck up here because the cases that get to that point there seems to be, I won't delve into the details, but there seems to be a pattern of misconduct. I didn't meet with the client. I didn't return the phone calls. I didn't file the documents that needed to be filed. When I was asked for a copy of the record from the client, I didn't provide it to him or her. Okay? And something ended up going bad in the case. And then that letter came from the bar. You're being investigated. And to add to these people's troubles, the people didn't respond to the bar complaint in a timely manner. So I guess the thing here that I want to emphasize is there seems to be a pattern. A pattern that seems to be related to disorganization and, frankly, procrastination. Okay. The next issue I want to deal with respect to diligence is the issue of competence and caseload. And this chart comes from some counsel that tracks this for criminal justice, and it's about 10 years old, this chart. But there was an issue several years ago with the federal government cutting funding to public defenders. And as a result, the public defender said, we're getting spread too thin here. And we may be having a competency, a diligence problem if we can't get to someone's case. So there are a series of, or a couple I should say, of advisory opinions on this issue. And the two advisory opinions, one comes from the American Bar Association, and two comes from the State of Utah Bar. And what they set forth, the topic of the opinions are the ethical obligations of lawyers who represent excessive or indigent criminal defendants when excessive caseloads interfere with competent and diligent representation. And on the right-hand column is the list of the things those decisions say you must do if you find you're in this situation. So 1, stop accepting new clients. Move to withdraw as counsel. If court denies the motion, you still have the obligation. Number 4, it places the obligation both on the lawyer who is in the trenches and his or her supervisor. And you have to notify the client of the impact of funding reductions on representation. I put this here because we are state attorneys, and we have, frankly, an endless pipeline of work that comes to us. And while this isn't in the context of public defender work, I think some of the principles here that we need to think about is our workload getting to the point where we are having either a diligence or a competence problem? So with that, I'll move on to diligence, zealous advocacy, and technology. I don't use Facebook, although my wife does. I have a LinkedIn account that I did about 15 years ago that I never use. I wouldn't know what to do with Twitter, okay? But some of you are more savvy with technology than I am. But as I peek at my wife's Facebook account to find out what's going on with our families and friends, there's a lot of stupid stuff that people put on Facebook. And it could be actually pretty good in terms of mining. So there are advisory opinions that deal with the parameters, the ethical parameters, when you start using these issues, these types of things in cases. The first I want to deal with is dealing with doing research on jurors. And you got the classic Norman Rockwell painting here of the lone holdout. And then you've got this sort of vague email on the left, which frankly I'm not quite sure what it says, but I think might be saying something about terrorism and drinking at 2 a.m. in the morning. Okay? But don't hold me. It was the best email I could find to do that. And what can a lawyer do to review a juror's internet presence and get additional information on that juror? In 2014, the ABA issued an advisory opinion on the issue. And one, you can review a juror's internet presence. Two, but you cannot communicate directly or through another with that juror or potential juror. Number three, you can't access or send an access request to the juror's electronic social media. And number four, if you discover that juror or potential juror's misconduct, you need to it requires disclosure to the court. And essentially, with respect to that, the theory is in this case that if you've got a juror that says, everybody, that defendant's guilty, okay, and that the defense that they're putting up is a crock, all right. There's a potential that a fraud can be perpetrated on the court, so it's your obligation. Furthermore, the ABA came out, or I'm not sure it was the ABA, but a model rule to advise jurors about this. But having said that, these are generally what the parameters are with respect to that. The next area that I want to deal with is you're in litigation and you want to find out the goods on a witness on the other side. And amazingly, most of the case law, most of the advisory opinions and publications go back to this New Hampshire Bar Association Ethics Committee advisory opinion, which in effect what it does is it deals with 7 different scenarios involving the use of social media to find out more information regarding a person. Furthermore, the New York State Bar Association, in many ways mimicking, but making a more user-friendly document, has made its own social media ethical guidelines. In my supporting materials, there are only 2 documents that I put in there. These are the 2. The New Hampshire decision is about 5 pages, and the New York State Bar Association guidelines, which you can Google, are about 35 pages. All right? Some of the questions, 4 of the 7 questions that were addressed in the New Hampshire case. Okay? One, can an attorney view a witness's unrestricted Facebook account? The answer is yes, because the public, it's a sort of public, everyone in the world can see it, so there's not an issue. If it's restricted, no, basically the answer to that is no. However, if you say to that person, I'm a lawyer in the case that you're involved in, and they say, yes, you can access my account, that's okay. If you lie about it, okay, then you've got a problem with misrepresentation, and the jurisdictions generally say, no, you can't do that. The jurisdictions are all over, but the New Hampshire case said you can't be anonymous in making that friending request. Number 3, can the attorney have their client do the dirty work for them? And the answer to that is yes. There's no prohibition to it, as long as we're not being deceitful. However, what about if the attorney, instead of having his or her client check out the account, they have an investigator who they've hired, or paralegal, or maybe a secretary do that? And the case law, no, because there's a specific model rule that addresses the issue that says you can't have your people who work for you do this. But that's not the case with your client. Therefore, it is probably okay. And lastly, if you know the witness is represented by counsel in the matter, can you access, and you're granted access, properly granted access to his restricted Facebook account, is there a problem with respect to that? The answer is yes. The rule is if someone else is represented by counsel, there's a no contact rule, and you cannot do that. I suggest that you read if you can Google it, the New Hampshire decision, or look at the social media guidelines, which sort of is a little bit more user-friendly, but because I think they'll be helpful to you, particularly those of you who are somewhat tech-savvy. All right. As the people who I worked with in public lands will attest, and as my daughter will attest, when it comes to technology, I'm a dinosaur. Until about a year ago, I had a flip-up cell phone until I sort of got my arm twisted to get one, to get a smartphone. But I think the important thing with respect to competence is comment number 8 to the Rule 1.1. And specifically, it's telling us we need to be familiar with the benefits and risk associated with relevant technology. I know that I can do email, I can do certain things on the internet, but I am no guru when it comes to technology. So I think the comments actually address that. There is no Utah opinion other than unencrypted email that I found that deals with technology. However, there's a fairly recent case in the state of California dealing with competency and confidentiality, and in the context of e-discovery. And the long and short of it is, you had this massive litigation. The attorney is required to provide e-discovery. Hard copies of documents are provided to the other side, and then there's other e-files. I don't know if I entirely understand the facts, but they had to provide those e-files too. And it turned out there were other documents that were apparently referenced in those e-files, but that had been destroyed unknowingly. So the accusation was made, you're hiding or you're destroying relevant documents. So the law, this case deals with that issue. Frankly, the decision in my mind, for me personally, and I suspect for some people, if you review it, is a little scary. There are I think there's about 10 or so things that the case says. And I'm going to tell you that about 2 years ago, the State Board of Education got sued with respect to its rulemaking procedure on Common Core, the adoption of Common Core standards. And my co-counsel, Nicole Call, did a fabulous job in getting that case dismissed. However, I was assessed with the responsibility of doing the e-discovery for all the emails and all the documents of the Board of Education and the USOE staff addressing the adoptions of those standards. It was a nightmare. And I suspect for the things that all of you do, I suspect that some of you have been involved in that, and I would hope that at least some of you would also tell me it was sort of a nightmare going through all those thousands and thousands and thousands of emails. This California case addresses the issue of what we're supposed to do when we get this e-discovery. I'll run through it very quickly, but one, we need to assess what e-discovery issues may arise. Two, do we have the e-discovery skills and resources to ensure competent representation? I'm going to stop right there and just say, if you don't, you need to get somebody on board who does. And that's either an attorney or an e-discovery expert. Number three, does the agency or the client that you represent have adequate electronic storage preservation procedures? Do we understand how that system works? Number four. And can we advise the client on options for the collection and preservation of that information? You need to engage in competent and meaningful meeting and confer with opposing counsel concerning the e-discovery plan. This is how we plan on going about it, which is part of what our thing was with Common Core. Perform the data search. Often, you will not be the one who actually does the data search. You will have someone else do that search for you. However, what you have to be cognizant of, you are the supervisor in that particular thing, so therefore you have obligations to make sure that that search is being done correctly. And then once that search is done, those documents need to be reviewed to make sure, are we giving out what is responsive to the request, and are we giving out anything that's either privileged information or trade secret or confidential in that context. And these requirements came out of a case in a couple of cases in the Second Circuit, which are listed below. Issues involving confidentiality. We're not supposed to reveal information unless the client gives informed consent, and there's under the ethical rules for this, there are basically 7 exceptions. The first, with respect to technology and confidentiality, is the use of unencrypted email. Now, I know we have it in our office, and I know we have it on a lot of our laptops at this point, and I know we've been given a flash drive that is encrypted. But the question is, if we don't use one of those things, or we do some work at home, or we do it in a restaurant, or there's a case involving a coffee shop, and it's not a secure line, are we violating the confidentiality provisions? And by and large, the answer to that, both from the state of Utah and from the ABA, is no. And the rationale behind it is that there's a reasonable degree of privacy with email, and that the amount of privacy with email is similar to the amount of privacy that we might have with a telephone call, with letters, the mail, things of that nature. So, by and large, both Utah and the ABA. Now, for some of us who do employment litigation involving state employees, well, let me back up for 1 minute. If we are communicating in an unencrypted manner or in an unsecure line account with our client, this ABA opinion says we really need to warn our client about that. And the facts of this particular case involved an employee who was suing his or her employer. It was an employment dispute. The employee was using the office email to communicate with his or her client. And when the dispute mushroomed and litigation started, the employer got all of the employees' business emails, and the court said that the attorney should have warned the employee that their communications may not be secure. So there's that notice, that warning you need to provide. Why did that come up? Well, all right. The other thing that the next case is another case out of California, which addresses the factors that you should look at in evaluating, just how secure of a system do I need to have? Okay? We know that there's not an ethical obligation to have an encrypted email, but one is, what are the capabilities of the technology system in place? Are only authorized people allowed to look at it? Are we changing our passwords? It's those types of things. Secondly, the legal ramifications of basically someone hacking into the system. That looks at, if they got into the system, would there be some type of criminal or civil action that could occur here? 3, how sensitive is the information? Obviously, the more sensitive the information, the more careful we need to be. Number 4, what is the potential impact on the client of the disclosure? Are we dealing with stuff that constitutes trade secrets or business confidentiality? Or is it pretty much sort of mundane stuff? 5, what is the urgency of the situation? Are there other alternatives here? And lastly, and probably always most importantly, what are the client's instructions? If the client said, nah, I don't care, we can do it. Or as the client said, no, we need to do all this on a secure line. Okay. I am negotiating at the current time a cell tower lease for Salt Lake Community College. And I have a Gmail line of emails that must be about 75 emails long, and every time something's done, it just adds and adds, and the thing is uncontrollable. I suspect some of us maybe have that in the cases that we're working on. What I resign myself to doing is starting a new email every time I actually do something on the thing. But what it gets to is the danger that we pass on with our email and how difficult it is to manage it, something that we shouldn't have sent on. And what are the ethical obligations if we get that unintended email that falls into our lap, that comes into our inbox? What do we need to do? And Rule 4.4b addresses this issue. And long and short, what that says, if it's an unintended email transmission, you need to provide notice to the other party. Okay? Now, comment 2 is, the next question addresses do I need to destroy it? Send it back to him? Can I read it? All of those things. The rules don't specifically address that. In fact, they specifically say, we're not going to address it. But what the basic rules are 1, the law of your jurisdiction or a court order will rule in this. If there is no specific law in your jurisdiction or specific court order with respect to the issue, then we are going to leave it up to the best judgment of the attorney at hand who gets it. And comments 2 and 3 deal with that scope issue, that we're not going to address the issue, and the best professional judgment. Utah has addressed this issue as well as the APA, and basically they say the same thing, is that you're required to give notice, but you're not necessarily required to give it back to them. In the case of 11460, that deals with it's actually in the context of looking at an employer looking at an employee's email, and there's a dispute between the two. I will note that State of California, in its opinion, has taken a little bit harder of a line. Of course, we're not in California, but what it's saying is you can't read it, and you got to notify the opposing counsel about it. I don't believe it says you have to return it. There are 7 exceptions to the confidentiality rule when we can do it. Obviously, if someone gives us consent, we can release it. But there are Utah advisory opinions deal with 3 of those 7. And one is, actually there's a couple here, address the issue of fraud. And if we have a situation where the client is involved in some type of fraudulent scheme, can the attorney advise either the insurance company that where the fraud is involved or law enforcement authorities? Those cases say yes. Well, one of them, the case where it's a fraudulent scheme, it's basically a money scam. And it involves an attorney-client relationship. The court says, yes, you can. The second case deals with a personal injury attorney who is dealing with clients, and he or she has picked up on the fact that the medical providers are overbilling the insurance companies. And it was a she in that case, can she disclose to the insurance company that from her client's files that this is happening? It's actually a pretty interesting case. And the answer in that particular case is no. In Spratley, that's a reported case. In that particular case, a longtime insurance defense attorney gets into a dispute with his client over fees, and there are confidential communications between the attorney and the insurance company, which he brings out. And the question is, can he do that? And the court says, goes to this rule and says, yes, in a dispute with a client, that confidential information can come out. The last case are cases that involve strange, but I guess there was a pre-sentencing investigation and a criminal case in one of these two. I've got a typo up there. I think it's 01 and 02. But it's sort of a strange case. There's a pre-sentencing investigation. There are prior convictions. And the judge asked the defense counsel, can you tell me more about the background between your client's previous convictions? And the question was, can that be disclosed? And the answer to that is no, not without your client's consent. In the second case, it's really an ineffective assistance counsel argument. And in that argument, they want to sort of put to vacate a guilty plea, they want to throw the prior attorney under the bus. And long and short of it is, under the theory that it's going to, the attorney who's being thrown under the bus wants to give his or her side of the story. And the long and short of it is, the court says, without the client's consent, you can't do that. Okay, issues involving communication. Let me see where we are here. Okay, I got 8 more slides. And I have till when? 10:30? Huh? Okay. Okay. You know, communication, in my mind, communication equals, the more of it you have, generally the more trust you have, and the less problems you're going to run into. I don't need to go through all of the different parts of the rule here. But we have 2 cases. One of these cases was on the train wreck slide, okay, back about 20 slides ago. The other one is a new case. But in the case on the left, there's a recurring pattern of no communication. And the court says there's a communication problem, a communication violation. On the other hand, the case on the right, it wasn't that there wasn't a communication, but it was that the State Bar Professional Responsibility section or committee, they got the wrong information in order to, and the wrong documentation was being provided and requested by the attorney from by the client, so they could address the immigration issue. In that case, court said communication is not the violation here. There was ample communication. The communication issue, it's not a communication issue. This is a competence violation. And you didn't find it on a competence. Okay. And obligations to surrender papers and properties to former client. Documents generated for your own purpose internally are not. There are two theories out there with respect to jurisdictions. One is the entire case file has to be provided. Some jurisdictions provide for that. The other one is only the end product documents are required to be provided. In other words, what comes through the sausage making process, the final product. The ABA bought into the argument that that basically only the end product needed to be provided and not the entire file. This involved the turnover of of 2 municipal attorneys. The contract ended for one. I think by looking at this ethics advisory opinion from Utah, I think that we have the same thing, that an unexecuted document, a draft of the document, doesn't need to be turned over. And for the purposes of time, I'll move on. Other issues involving communication, we have an ethical opinion that says if we've got a beef with a judge, we've made the judge has got a conflict of interest and it's caused some consternation, we have to disclose that to the client. And Babyliss is another reported case on this. That's basically poorly explaining a fee arrangement for a person or for a client, and there were a lot of other violations in that case. Communications with the opposing party. The essential rule is, we're familiar, if they're represented by another party and they're represented by counsel, you can't communicate with them. All right? A couple of formal opinions here. Client can communicate with the opposing side. In other words, the attorney can ask the client to communicate with the other side. There's no ethical prohibition of having your client ask for that. Attorney can't communicate for the limited purpose of figuring out whether the other side's attorney passed on a settlement offer. And because most of us represent government employees or government representatives, I didn't find any Utah cases specifically, advisory opinions specifically on this, but essentially these 3 cases say, one, for the people in the trenches, it was in a zoning or a planning matter, the first case, if they're represented by counsel and they're a government employee, can't talk to them. Case number two, if they're an elected representative, they're represented by counsel, you can't you can't talk to them unless you get consent. Number three is a fairly recent case. It doesn't deal with government. It deals with more private entities, and it deals with making friends with others on Facebook. And basically, you can't send a Facebook request to a high-ranking official of a corporation who's on the other side of a dispute. And in conclusion, what we've talked about today are one, the antitrust implications or potential antitrust implications, the regulation of practice of law. Two, what the disciplinary violations that are being conducted by Utah's bar. And lastly, relevant issues with respect to certain rules involving diligence, confidentiality, and communication. That's the end of my presentation. Are there any questions? Yes. Yep. Yep.
So you have a confidential conversation.
I think it's a practical matter. No, I would, because it was said to me in a confidential manner. If push comes to shove, I might have to back off in that position. But my initial reaction to that would be, no, I would not tell the supervisor straight up unless the person who told me that in confidence gave me the okay to do that. But repeating myself, if push came to shove, I might have to back off on that position because the argument, and God knows it was in a former client of mine, that was a very constant issue. Was it the State Board of Education was the client, or was it the staff who was the client? Technically, it was the State Board of Education. Okay, and so you may, in the end, you may have, if someone on exec is the client that you're dealing with in that agency, my sense is that you may at the end have to disclose. I fight like anything not to have to do that, because it'll hurt your relationship with the people in the trenches. Does that answer your question? Yeah. Okay. Are there any other questions? All right. Thank you very much.